Hello friends, I'm Sanjay and this is part 7 of the series where I'm covering the interpretation of statutes and the principles of legislation as per the standard LLB syllabus. The complete playlist is available on the Lawment YouTube channel. In the previous sessions, we have discussed about how statutes can be classified on the basis of their duration, that is perpetual or temporary statutes, on the basis of their nature of operation, that is prospective or in a very few cases retrospective statutes, directive or mandatory statutes, or on the basis of their objective, that is codifying, declaratory, remedial, amending, consolidating, etc. We have also discussed the need for interpretation, the aids to interpretation, the presumptions during interpretation, and also the primary and secondary rules of interpretation. In this session, we will look at how the primary and secondary rules or principles of interpretation are applied to different types of statutes. For example, penal statutes and taxation statutes are to be interpreted strictly, whereas any of the social welfare statutes need to be interpreted beneficially. What are taxing statutes? These are nothing but statutes dealing with the levy of any kind of tax. They can also be called revenue statutes since they generate revenue for the government. These taxing statutes may deal with direct taxes like income tax or wealth tax, or indirect taxes like the GST. Without looking at the bigger picture that taxes are ultimately used for the welfare of the people, if we look at the immediate effect of a tax, it creates a burden on the person who is paying the tax. If taxes are not paid, then the taxing statutes may create a liability, a penalty, or lead to a punishment on the person who is being taxed. So, if a statute has the potential to create any kind of burden, liability, penalty, or punishment on the people, it should be interpreted strictly. Now remember, the strictness is on the statute and not on the person, which means that if a tax statute is not fully clear about whether a particular transaction is taxable or not, the benefit of that doubt should go to the person who is being taxed. Strict interpretation means that the scope of the statute is limited to whatever is specifically mentioned in that statute. No additional taxes can be inferred, implied, or extended beyond what is specifically written in that law. For example, when e-books started becoming popular, then the tax laws still had not caught up with the concept. So, if you were selling a book in both physical and digital versions, only the physical sales could be taxed, and the digital copies were exempt, because the tax laws did not specifically mention anything about digital books. So, the strict interpretation of tax statutes meant that the benefit of the gap in the law went to the publisher, till the law was amended to include digital goods also into the tax net. In summary, if a taxing statute needs interpretation, then the courts will first apply the primary rules of interpretation, such as the literal rule, the golden rule, the mischief rule, etc. And the outcome is interpreted strictly, and it is interpreted in favor of the person. The other basic principles to be followed include harmonious construction, so that the interpretation does not lead to contradictions within the statute itself or with other statutes. Also, new tax laws should be applied prospectively on transactions occurring after the enactment of the statute and not on past transactions that occurred before the law became effective. And the beneficial provisions of a statute that give any exemptions, deductions, or rebates must be interpreted to benefit the taxpayer. And any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. Penal statutes or criminal statutes define that specific activities are illegal or criminal and prescribe some penalties, liabilities, or punishments. The interpretation of penal statutes is similar to that of taxing statutes, because even here the rule of strict interpretation is applied. The meaning of strict interpretation means that if an action is not specifically defined as being illegal or criminal under the statute, then the person who is being accused cannot be penalized. If there is any ambiguity or doubt, then the benefit of such a doubt goes to the person who is being accused. For example, smoking cigarettes or BDs in public places is illegal and people can be punished for doing so. But when e-cigarettes became popular, the statutes at that time were not clear. Is smoking e-cigarettes in public places a crime or not? For the purposes of the statutes, are e-cigarettes considered to be in the same class as regular cigarettes or not? So these were the questions where there was not much of a clarity. Since there was a doubt and the strict interpretation was applied, it meant that people could not be punished for using e-cigarettes in public places, unless and until the statutes were amended or updated. If a penal or a criminal statute needs interpretation, then the courts will first apply the primary rules of interpretation, such as the literal rule, the golden rule, the mischief rule, etc. And the outcome is interpreted strictly, and strictly in favor of the person. While interpreting penal statutes, the concept of mens rea or guilty mind also becomes very important. That is, unless the statute explicitly says so, an act will not be a crime unless the person intentionally commits it. If an act was unintentionally committed or accidentally committed, then it will not automatically become a crime. The other principles that are applied are beneficial construction and harmonious construction. Another important aspect about penal statutes is that a person cannot be punished for an act that was not a crime when it was committed. That is, penal statutes cannot be applied retrospectively, and this is also specifically prohibited by the Constitution. For example, if a statute banning e-cigarettes was enacted from the 1st of January, then a person cannot be punished for having used e-cigarettes on the previous day, that is, the 31st of December. And as usual, any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. Social welfare statutes are enacted to promote social justice and provide benefits to the people. For example, the Mahatma Gandhi National Rural Employment Guarantee Act, the Right to Education Act, the National Food Security Act, or the Rights of Persons with Disabilities Act. Since the objective of such statutes is to extend benefits or to ensure the welfare of the people, they should be interpreted beneficially and liberally to ensure that all the intended beneficiaries are covered. For example, if there are some benefits that are to be extended to people with disabilities, and there is a question about some disabilities that are not specifically listed in the statute, then the court can use common sense and reasonable construction to see if the disabilities in question should be covered under the statute or not. If there is a reasonable doubt, it should ideally be interpreted in favor of the beneficiaries, because it is okay if a few unintended persons benefit from the statute. No intended beneficiary should be deprived. As is the case with all statutes, if there is a need for interpretation, the primary rules are applied first, and then for social welfare statutes, the court should use beneficial interpretation. Another point to remember here is that social welfare statutes should be interpreted dynamically to ensure that the statutes stay relevant with the changes in the society. For example, there are some laws and rules that offered some benefits to people working in offices. And after the COVID pandemic, working from home also has become normal, which means that the statutes that covered work from office should be suitably interpreted to cover employees who are working from home also. And any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. Your university syllabus for this subject may include a topic Interpretation of Substantive and Procedural Statutes, or it may say Interpretation of Substantive and Adjunctive Statutes, or it may say Interpretation of Substantive and Adjective Statutes. If you pause the video here and read the dictionary meanings of the words adjunct and adjective, you will see that in the context of laws or statutes, they are referring to the same thing, that is, procedural statutes. The terms substantive and adjective seem to have been invented by Bentham in 1843 and subsequently popularized by Holland when he used these terms in his book. But these days the preferred term is procedural, since adjective and adjunctive do not clearly indicate the purpose of these statutes. A simple example of a substantive law and an associated procedural law are the Bharatiya Nyaya Sanhita and the Bharatiya Nagarik Suraksha Sanhita. The Bharatiya Nyaya Sanhita defines various crimes and specifies the punishments. So this is a substantive law. And the Bharatiya Nagarik Suraksha Sanhita provides the procedures for giving effect to the substantive law. So this is a procedural law. As I have previously mentioned, procedural or adjunctive or adjective statutes are all referring to the same thing, that is, procedural laws. Modern jurists prefer to use the term procedural law because it provides more clarity as to what is the purpose of the law. It is easier to understand the interpretation of substantive and procedural statutes if we study them together. First of all, there are substantive statutes which define legal rights, duties, obligations and liabilities. For example, the Bharatiya Nyaya Sanhita, the Indian Contracts Act and the Transfer of Property Act are all some examples of substantive statutes. Then come the procedural laws, and as the name itself indicates, they provide the procedures for implementing the substantive laws. For example, the Bharatiya Nagarik Suraksha Sanhita provides the procedures for implementing the Bharatiya Nyaya Sanhita. And if a substantive law needs some interpretation, then the courts will first apply the primary rules of interpretation, such as the literal rule, the golden rule, the mischief rule, etc. And the outcome is interpreted either strictly or beneficially depending on the nature of the statute. Is it a penal statute, is it a welfare statute, or any other type? The rule of casus omissus is also applied here, which means that if something has been omitted or is missing from a statute, then the court should not try to fill that gap through its own interpretation. The court should interpret the law as is. Procedural law is always subservient or secondary to the substantive law, which means that the procedural law cannot supersede or override the substantive law. For example, the Bharatiya Nagarik Suraksha Sanhita cannot take away anything that the Bharatiya Nyaya Sanhita has mandated, or it cannot add something that the Bharatiya Nyaya Sanhita has prohibited. Procedural statutes are generally interpreted liberally because their purpose is to enable the implementation of the substantive law and not become a roadblock. The Supreme Court has also noted that a substantive right accrued to the litigant should not be defeated by citing a procedural defect that is capable of being cured, which means that minor procedural irregularities can be overlooked if they don't affect the substantive rights or the merits of the case. And in general, procedural laws apply prospectively because a law should not create a new procedure and expect that procedure to have been followed in the past from before the enactment of the statute. And as usual, any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. Directory provisions are non-mandatory clauses or instructions or guidelines within a statute. They guide or recommend certain actions, but non-compliance with these directory provisions does not automatically invalidate the actions or the proceedings that they relate to. Directory provisions often use the words may or recommend. One way of identifying whether a provision is directory or mandatory is to see what is the effect of the non-compliance. If there are no penalties or liabilities or negative repercussions due to non-compliance, then it is a directory statute. Otherwise, it is mandatory. This test was also reconfirmed by the court in a landmark 1994 case. While interpreting a directory statute, the context and the purpose of the statute must also be taken into consideration. And if the statute is directory, then an approach of substantial compliance can also be used, which means that if a person has made a reasonable effort to comply with the provisions, that can be considered sufficient, even if the compliance is not 100%. This point was also reiterated in a 1955 case that non-compliance with a directory provision should not lead to an adverse impact unless a prejudice is caused to the other party, which means that even substantial compliance is okay as long as there is no real harm that is caused by the partial compliance. And the court can also take into consideration whether strict compliance with the provisions or lenient compliance best meets the tests of reasonableness and best serves public interest. And as with any statute, any interpretation must be validated against the presumptions as to the interpretation of statutes. Mandatory provisions are those parts of a statute that are compulsory. These are not advisory or optional or suggestions. Wherever they are applicable, they have to be followed. Not following a mandatory provision may lead to an action or a transaction being deemed as illegal, void, or unenforceable, or it may lead to certain penalties. For example, if your taxable income crosses a certain threshold, you need to pay taxes and file tax returns. This is not optional, it is mandatory, and not doing so can lead to interest, fines, and other penalties. Or the Contract Act may set out some provisions that are essential for a valid contract, and not following them can lead to the contract being declared as null and void. To identify whether a provision is mandatory or directory, we can use some basic guidelines, such as if non-compliance with some provisions leads to some penalties, results in some liabilities, or has some negative effects on some rights, then it is a mandatory provision. Or if a provision has the words must, shall, or ought to, then it is an indication that it is a mandatory provision. Or by reading the provision contextually, what is its position within the statute? What is its relationship with other statutes? We can identify if a provision is mandatory or not. The process of interpretation of mandatory statutes, as usual, starts with the application of the usual primary and secondary rules. And depending on the purpose or the nature of the statute, either strict or beneficial construction is followed. And in every step of the interpretation process, we should validate the interpretation against the presumptions, such as the presumption that the legislature would not have made unconstitutional laws or intentionally created absurd laws. Codifying statutes create the code, usually where there is no specific law covering the subject, or there are several laws that overlap on the same subject. In other words, codifying statutes are comprehensive pieces of legislation that systematically arrange and present the law on a specific subject in one document. For example, there was a time when crimes were dealt with by various local customs or under different laws in different regions of the country, and the same crime could be treated in a different way in different regions. The government of that time created the Indian Penal Code, which standardized the definitions of various crimes and prescribed the punishments for such crimes, as would be applicable in a standardized manner all across British India. More recently, with the many social, economic, political, and cultural changes that are happening in the society, there was a need to ensure that the criminal laws are updated and consolidated for the current requirements. So, the Bharatiya Nyaya Sanhita was enacted to replace the Indian Penal Code. Similarly, the Indian Contract Act was enacted to codify the law of contracts, especially since the concept of contracts was dealt with under the customs and traditions of different communities and regions of the country. And there was a need to standardize the rules and procedures related to contracts. Therefore, we can see that the main objectives of any codifying statute are clarity, coherence, accessibility, and certainty. Another example of a codifying statute is the Prevention of Sexual Harassment of Women in the Workplace Act. While deciding on the Vishaka versus State of Rajasthan case in 1997, the court saw that there was no single statute that dealt with this topic comprehensively. First of all, the court noted that sexual harassment is a violation of Articles 14, 15, and 21 of the Constitution, and also that India is a signatory to the UN Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW. Therefore, there was a need to have one comprehensive codifying statute to deal with this important issue. And in the absence of any such specific codifying statute, the court published a set of guidelines which were popularly known as the Vishaka Guidelines in 1997. And much later, in 2013, the government enacted a comprehensive codifying law on that subject, which is the Sexual Harassment of Women at the Workplace Prevention, Prohibition and Redressal Act. As far as the interpretation is concerned, it starts with the application of the usual primary and secondary rules, and depending on what is the purpose or the nature of the codifying statute, either strict or beneficial construction is followed. And any interpretation of any statute must be validated against the presumptions as to the interpretation of statutes. Consolidating statutes are laws that combine various statutory provisions on a particular subject into one comprehensive statute, which is what the term consolidation actually means. For example, as the concept of companies was adopted and evolved in India, companies were initially governed by the Joint Stock Companies Act, followed by the Companies Act, and later the Indian Companies Act. And eventually, some other statutes were also enacted. The Companies Act of 1956 consolidated all the statutes that preceded it into one specific statute. And eventually other laws and rules also evolved along with the changes in the social, political and economic environment of the country. So the Companies Act of 2013 consolidated the Companies Act of 1956 and other laws related to companies that were prevalent at that time. So what we can see here is that whenever the law on any subject starts to become too wide and spreads across multiple statutes, then a consolidating statute is enacted to repeal the previous statutes and create a single authoritative statute. The consolidating statute will also simplify and clarify any doubts in the previous laws and also bring in any required updates and remove inconsistencies in the previous laws. Coming to the interpretation of consolidating statutes, their primary objective is to simplify and clarify the previous laws, and this should guide the interpretation process as well. The courts will presume that unless specifically stated, the consolidating statute does not intend to bring in any significant changes as compared to the previous laws. Since consolidating statutes are practically built upon previous laws, the historical context of the previous laws should also be considered before interpreting the new statute. That is, what was the intent of the original law and whether the new law has a different intention. The rule of harmonious construction is also relied upon to ensure consistency and avoid any conflicting interpretations. And any interpretation of any statute must be validated against the presumptions as to the interpretation of statutes. As the name itself suggests, statutes conferring rights are intended to provide some rights, privileges, or benefits that can be claimed and enforced by the people who are covered by the statute. These rights can be civil rights, political, economic, social, or cultural rights. These statutes may grant new legal rights that did not exist previously, or they may clarify or expand upon existing rights, or they may detail the application of existing rights. Some example of statutes conferring rights are the Right to Information Act, which grants citizens the right to access information from public authorities, or the Hindu Succession Act, which grants daughters also the same rights as sons in terms of inheritance of property, and the Consumer Protection Act, which provides for the protection and enforcement of consumer rights. Coming to the interpretation of these statutes, the principles of liberal or beneficial interpretation are used to ensure that the primary objective of these statutes, which is to grant or to protect rights, are achieved. Strict interpretation of certain parts of the law is done to ensure that these rights are not misused. Harmonious interpretation is used to ensure that there is no conflict between the statutes conferring the rights and any other statutes. And the purposive interpretation approach is used to ensure that the rights that are granted are within the scope of what the legislature actually intended. For example, in the Society for Unaided Private Schools of Rajasthan versus Union of India decision, the court purposively interpreted the Right to Education Act to say that even private unaided schools are also required to follow the EWS reservation policies. By doing so, the court ensured that the objective of the Act to grant and protect the right to education is achieved. And finally, as with any other statute, all interpretation of statutes conferring rights must also be validated against the presumptions as to the interpretation of statutes. Someone asked, what is the difference between statutes conferring powers and enabling statutes? Aren't they the same thing? Well, they are similar, but they are not the same. I have collated the differences between statutes conferring powers and enabling statutes in this table. You can pause the video and read through this table. But the key difference between these two types of statutes is in their typical scope. Statutes conferring powers empower or enable existing entities. For example, the Bharatiya Nyaya Sanhita enables existing police departments, whereas enabling statutes typically facilitate the creation of a new entity and then enable or empower them. For example, the SEBI Act led to the creation and enabling of SEBI. We can say that statutes conferring power tend to be more specific and limited in scope as compared to enabling statutes. Statutes conferring powers are enacted to grant or to delegate specific powers to specific individuals or bodies. These are powers to perform specific functions or to take some decisions on a specific subject. For example, the Motor Vehicles Act confers powers on the state transport departments to regulate road transport within the respective states. It includes authority over vehicle registrations, issuing driving licenses, and enforcing traffic rules. Another example is the Bharatiya Nyaya Sanhita, which grants specific powers to police officers regarding arrests, searches, and investigations. The powers that are granted or conferred by these statutes can range from administrative or regulatory functions or enforcement and decision-making authority. If we look at statutes conferring powers in general, they enable the executive to perform their functions by giving them the requisite powers. Coming to the interpretation, it starts with the application of the literal, golden, and mischief rules. Strict interpretation is followed to ensure that the powers granted are within what was intended by the legislature. The purpose and the legal context of the statute are also considered to interpret the scope of the power. Any powers must be explicitly conferred, and if there is any ambiguity or lack of clarity, then it is interpreted against the grant of that power. If any powers are to be implied, then they must be absolutely essential for performing the intended functions. For example, if the traffic police are given the function to regulate traffic, it can also be reasonably implied that they have the power to declare certain roads as one way or create rules to restrict certain vehicles on certain roads at certain time. The court will also consider any limitations that have been laid down on the exercise of such power, either within the same statute or elsewhere. And as usual, any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. I have previously explained that though there are similarities between statutes conferring powers and enabling statutes, they are not the same. You will notice that the scope of enabling statutes is more than the scope of statutes conferring powers. Enabling statutes, in general, create specific entities or organizations and also empower them to create laws, rules, and regulations within specific areas. For example, the Securities and Exchange Board of India Act or the SEBI Act enabled the creation of SEBI and also conferred the powers on SEBI to regulate the domain of financial securities and stock exchanges in India. Similarly, the University Grants Commission Act enabled the creation of the UGC and also conferred powers on the UGC to regulate universities across India. While interpreting enabling statutes, as usual, the courts will first apply the primary rules such as the literal, golden, and mischief rules. Strict interpretation is used to ensure that the authorities or the entities that are created act within the limits set by the enabling statutes. Purpose-oriented approach is used to ensure that the purposes of the enabling statute are addressed. Harmonious construction to ensure that there is no conflict within the same or with other statutes. The organizations that are created and the powers granted to them should all be in compliance with the Constitution. And the rules created under the enabling statute should be reasonable and comply with the procedures prescribed by the enabling statute. And any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. Before moving ahead, let me quickly explain what is delegated legislation. Normally, the legislature has the authority to make the law and the executive implements the law. However, the central legislature, that is the parliament, and the state legislatures cannot be expected to make all the laws at every level. The legislature often makes the laws at a higher level and delegates the authority or the powers to make low-level laws to the executive itself. How does the legislature delegate the powers to the executive? This is done either through enabling statutes or through statutes conferring powers. We have already discussed how enabling statutes facilitate the creation and empowerment of new entities, and statutes conferring powers empower existing entities. The lower level laws that are made by the executive are nothing but the rules and regulations on specific subjects. These are also called delegated legislation or subordinate legislation. The executive to whom the powers have been delegated can be a ministry, a commission, a board, or other authorities. As I have already mentioned, delegated or subordinate legislation refers to the rules and regulations made by the executive authorities under the powers granted by an enabling act or an act conferring power. The executive authorities can be existing institutions like ministries or various departments who are empowered by a statute conferring power, or they can be commissions or authorities established under an enabling statute. The interpretation of the delegated legislation is quite straightforward. The delegated legislation and any interpretations of the same must be intra vires. That is, it should be within the scope allowed by the enabling or the empowering act. It cannot exceed the scope and cannot contradict the main statute. The court established this principle of intra vires in the Express Printers versus Union of India case. The interpretation should be reasonable and should be in accordance with the purpose and the objectives of the enabling or the empowering statutes. The interpretation should be clear and unambiguous. The delegated legislation should have been made as per the procedure established by the main legislation and should not contradict any constitutional provisions. If all of these requirements are met, then the delegated legislation, that is, the rules and regulations, should be treated as a part of the main act itself, which means that they get equal importance as the main acts and are not just considered as administrative directions which are optional. In the Delhi Laws Act case, the court clarified that there are some limits to what the legislature can delegate to the executive. The court ruled that defining the policies is an essential legislative function that cannot be delegated. Only the powers to make the rules and regulations to implement the policies can be delegated. Let us now look at the interpretation of international treaties. International treaties are formal agreements between sovereign states or countries. These treaties can be on a wide variety of subjects like trade, culture, human rights, environment. They can also be peace treaties, either to end an existing conflict or to prevent future hostilities. Treaties can have a significant role in the foreign trade policies and international legal obligations of a country, and they can also significantly influence national laws. For example, India is a party to several international agreements under the World Trade Organization, and on the basis of these agreements, changes have been made to our trade policies, our intellectual property laws, and our regulatory standards as well. International treaties can be bilateral, that is, between two countries, or they can be multilateral, that is, between 3 or more sovereign states. The Vienna Convention on the Law of Treaties is the key international agreement that provides a comprehensive framework for the creation, interpretation, and enforcement of treaties. Section 3 of this document specifically covers the interpretation of treaties. Under Article 31, General Rule of Interpretation, Article 32, Supplementary Means of Interpretation, and Article 33, Interpretation of Treaties authenticated in 2 or more languages. Article 31 says that the treaty should be interpreted in good faith and the ordinary or normal meanings should be given to the terms used in the treaty. Only if the parties to the treaty specifically intended to do so, special meaning should be given to any terms. While interpreting the treaty, the complete text should be taken into consideration, including the preamble and any annexes. Also to be considered during the interpretation are any other agreements made by the parties in the process of concluding the treaty and any agreements made by the parties after the conclusion of the treaty, as long as all the parties to the treaty accept all these other agreements. One more important point to be taken into consideration while interpreting treaties is any international laws that are applicable in the situation. Article 32 talks about any other supplementary material, including the preparatory work for the treaty that can be used for subsequent interpretation, if the interpretation under Article 31 is leading to an ambiguous, absurd, or unreasonable meaning. And Article 33 addresses situations where a treaty has been authenticated in multiple languages, which may be the official languages of the respective countries. It simply says that every authenticated version will be valid, irrespective of the language, if these different versions are as agreed at the time of the original conclusion of the treaty. If subsequent interpretation is leading to a different interpretation of the different language versions of the treaty, then the interpretation that best reconciles these different versions will be adopted, as long as this interpretation is still in accordance with the object and purpose of the original treaty. For example, if a treaty between England and France was concluded in English and French versions, and both versions were agreed and concluded upon originally, and many years later due to changes in the language or other changes in the society, there is a difference in the interpretation of the different versions of the treaty, then the interpretation that best reconciles these different versions will be adopted, as long as this new interpretation is still meeting the object and purpose of the original treaty. With that, we have come to the end of this part about the interpretation of different types of statutes. If you have any questions or feedback, post a comment below. Thank you in advance for your like, share and subscription. We will meet again in the next video. Take care and Jai Hind.